even after it was increased. He stressed that when his complaint failed to yield any success, he sought the service of a lawyer who forwarded separate complaints to the defendant and office of the secretary to the government of the federation. Just a minute. Continuing, he stated that genuineness of his claim was affirmed by the SGF via correspondence dated 4th of August 2021, but it was contended that his salary grade level, according to computation provided by Sokoto State, is grade level 13, and his lawyers, upon receipt of this, wrote a letter to the defendant expressing their displeasure. He averred further that upon the receipt of the defendant's response, he engaged the service of a chartered accountant firm who, after reviewing relevant documents, affirmed that his retirement benefit include 1,603,573 naira 6 kobo as gratuity, 19,939,397 naira 78 kobo for short payments, and other uncertain pension payments arising from wrong placement on grade level 13 instead of grade level 17. Step 5, that despite all his correspondence to the defendant refused to pay him all his entitlement as contained in his claim, which has cost him untold hardship, as he has to overstrain himself to feed members of his family. This against this backdrop, that the claimant by general form of complaint filed a suit against the defendant on the 21st of March 2022, praying to the court for the following reliefs. 1, a declaration that the claimant retired voluntarily in 1989 as Chief Inspector of Education, grade level 17, step 5, after 32 years of service of the Northwest of Northern Nigeria and Sokoto State, respectively. 2, a declaration that the defendant's action placing and/or computing claimant's pensions on grade level 13, which is the pension due to Chief Education Officer, is unlawful or travails the powers of the defendant and unconstitutional. 3, a declaration that the defendant is under constitutional and statutory duties to pay its portion of the claimant's gratuity and all the arrears of pension, particularly from 1989 to 2002. 4, upon grant of prayers 3 above, is also seeking for an order of the court compelling the defendant to pay to the claimant designated bank account the sum of 1,603,573 naira 6 kobo, being claimant's due gratuity from the defendant as assessed and/or stated computation sheet forwarded to defendant from Sokoto State. 5, upon grant of prayers 1, 2, and 3 above, an order of this honorable court compelling the defendant to pay into the claimant the sum of 19,939,397 naira 78 kobo, being the short payment or differentials of pensions based on grade level 13, step 5. 6, upon grant of prayer 5 above, an order of this honorable court compelling the defendant to pay into the claimant designated account the pension payment of deficit resulting from placing the claimant on grade level 13 as against grade level 17, step 5, or in the alternative to prayers 5 and 6, an order of a court compelling the defendant to immediately cause all claimant's pensions benefits to be transparently computed on grade level 17, step 5, provide for all the pension payments deficit, and settle and/or pay all claimant's pension entitlements into his designated bank account within 30 days of delivery of this judgment. 8, the sum of 100 million naira being general damages or aggravated damages for whimsical and deliberate refusal of the defendant to work with the information or advice from Sokoto State government on correct grade level of the claimant, thereby subjecting him and his family to untold hardship and sufferings. And 9, the cost of this action. The defendant, in response, filed its statement of defense on the 12th of May 2022, wherein it contended that by the establishment of service for both federal and state service, a chief or chief inspector of education has from inception been placed on grade level 14 in the federal service on grade level 13 and in the state civil service, and that there has never been a time a chief or chief inspector is placed on grade level 17 as claimed by the claimant. It contended that the federal government took over the payment of gratuity and pension of state with federal share from the 1st of June 2002, and as a result, the defendants, the ability of state pensioners for any federal share gratuity and pension commenced from June 2002 and not before A. Hence, the claimant is not qualified for payment of gratuity under the defendant scheme because his retirement predates 1st of June 2002. It also averred that the claimant's monthly pension based on recent consequential pension adjustment is the sum of 33,473 naira 99 kobo, and 21 out of 24 months arrears owed to him as a result of the said adjustment have duly been paid to him. And for the claimant to be entitled to recalculation and payment of any additional possible pension arrears, it is mandatory that he provide requisite documents to substantiate such claim, which to date, claimant is here to provide. Upon complaint made by claimant in 2014, it was requested to submit relevant employment and retirement documents, but it was only able to provide a computation sheet not authenticated by the Auditor General of Sokoto State, contrary to the defendant's policy. Upon a request for confirmation of actual grade level for retired education officers in Sokoto State, designated as Chief Inspector of Education, it was discovered that the rank on which claimant claimed he retired never existed in Sokoto State establishment, but that there is a rank of Chief Education Officer, which is placed on grade level 13, wherein the claimant's computation was based using the Pension Annual Harmonization Table 1994, an approved salary chart for officers who retired before 30th August 1998, and the computation of 2015 took care of all harmonization increases, and thus there is no need for further harmonization since it was computed in 2015, contrary to the one computed by claimant, which is not in tandem with the extant policy, and also that it made effort to resolve the disparity created by the computation sheet in 2018 by writing the Permanent Secretary Sokoto State Pension Department in order to clarify the grade level which the claimant retired, but no response has been received in respect of this. The defendant further contended that claimant had instituted an early action in suit number NICN/195/2016 against the defendant, and which suit parties agreed will be withdrawn, and claimant was equally to provide a comprehensive bank account, which he failed to produce. Instead, he resorted to filing this present suit, which is separate from his earlier suit. Defendant equally filed a notice of preliminary objection on the 12th of May, 2022, contending that this matter as presently constituted is an abuse of the process of court, and that it diverts this court the requisite vials to adjudicate upon same. The grounds upon which the objection is brought are: 1, that the same matter between the same parties and on the same subject matter pending before the same court in suit number NICN/ABJ/195/2016. 2, that the claimant claims in suit number NICN/ABJ/195/2016 is for arrears of his pension and gratuity, which is same with present matter. And 3, that this matter as constituted is an abuse of the process of this court. Is therefore seeking an order of court dismissing or, in the alternative, striking out the suit for having been wrongly constituted in abuse of the process of court. And in support of this, filed is a 9-paragraph affidavit and a written submission. I've reduced the written submission into the body of this judgment. And in response, the claimant filed 7-paragraph affidavit, and I equally filed a written submission. I've reduced that equally into the body of this judgment. On the 6th of February 2023, claimant opened his case by testifying for himself as CW. He adopted documents. He adopted his sworn deposition. He equally tendered documents admitted and marked as Exhibit A to A5. He was cross-examined by the defendant. one Nathan Ini testified on behalf of the defendant, equally adopted his sworn deposition, tender documents, and 18. He was also cross-examined by the claimant counsel. And at the close of trial, both parties filed their final written addresses. I've reduced that into the body of this suit. So I'll go straight to the decision of the court. After a perusal of the originating process with all the accompanying processes and documents, statement of defense and all its parties, the preliminary objection filed by the defendant and the counter affidavit, I'm of the firm view that the two issues for determination before this court are, one, whether or not this suit is an abuse of the process of court and thus divest this court the power to adjudicate on it, and two, whether or not the claimant is entitled to the relief sought. Respecting issue one, it is a contention of the defendant that this action constitutes an abuse of court process, divesting the court of requisite jurisdiction to adjudicate upon same. The position of the law is so clear that the issue of abuse of court process is so fundamental that it has over the years assumed the toga of jurisdictional issue and has the capacity to terminate the proceeding or suit or matter in limine by way of dismissal. Thus, no court has jurisdiction to entertain a matter which is founded on abuse of the process of court. See the case of Vessel MT Silla and another versus Ghana Commercial Bank Limited and order citation captured, Imuse and another versus Ojesuya and order citation provided, Mohammed and Dantata and order citation also provided. The law is of common that where jurisdictional issue is raised, it must be considered first. This is because jurisdiction is a radical and crucial question of competence without which a court lacks the power to entertain a case. See the case of LLSP IA Limited versus MT Tuma, citation capture, the case of Ingere and Okuruket, number 19, citation provided, Diamond Bank and Gochuku, citation also captured. In the same vein, the courts over the years have maintained the position that the issue of abuse of the process of court being one that affects the competence of the suit and thus jurisdictional, once raised has to be decided to determine whether the matter is bona fide before the court, before the merits of the case is considered. And that's why I'm considering that first here. See on this, the case of Dugari and Waziri and another, the case of Ukachuku and PDP, citation provided, the case of Chime and Unya, citation equally provided. The above is so because any defect in competence is not only intrinsic, but also extrinsic to the entire process of litigation. Therefore, any judgment of court, however well written, without jurisdiction is nothing but a nullity. I place reliance on this case is Adiagban and Military Governor Lagos State, citation provided, retired Honorable Emeka Ihilde, Right Honorable Emeka Ihilde Ihedioha, and another versus Owele Rochas Anayo Porocha, and 36 orders citation provided. Dalfa Nigeria Limited on Okaka International Limited, citation captured. The defendant or objector read its paragraph 3.05 of its written address in support of the preliminary objection, contending that claimant's case in suit number NICN/APJ/195/2016 is still pending. Thus, the matter remains subsisting and dormant to date. Claimant respondent in opposition bid paragraph 4 of its counter affidavit proceeded that since 2017, he instructed his then counsel to discontinue the suit, which he assumed the case had been terminated and struck out. It is clear from the defendant's objectors exhibit A3 that parties in the said case appeared last before the court on the 30th of May 2017. He continued by stating that having discovered that the matter was merely abandoned by erstwhile counsel, he applied for discontinuance or withdrawal, and same was granted, and the case was discontinued and struck out by this court. It needs to be stated that what amounts to an abuse of process of court has been given judicial definition and explanation by the Supreme Court and the Court of Appeal, plethora of judicial decisions. From the definitions given by the courts, abuse of court process is not capable of a precise or concise definition. Nonetheless, what is clear from the definition is that abuse of court process involves a situation where the process of court is used malafide to achieve an improper or unlawful result. These cases are pungent. Adegbanke and Ojelabi, citation captured. Adamu and FRN, citation provided. Honorable Justice Titus Adeni and Oyewumi retired, and others, citation provided. A case of Ogboru and another Oduahan and other, citation provided. African Continental Bank PLC and Nwaigwe, citation provided. Notorious case of Saraki and another, and Putoye, citation provided. It is noteworthy that the list of what amounts to abuse of the process of court are not closed. An abuse of the process of court can manifest in a variety of ways, one of which is the multiplicity of actions between same parties on same issues, seeking the same relief. It is clear that abuse of process of court includes, but is not limited to situations where the same issues and subject matters are relitigated upon or between the same parties, especially the Apex Court in the notorious case of Saraki and Kutoye Supra, in a unanimous decision, held a multiplicity of actions on the same matter between the same parties, even where there exists the right to bring the action, is regarded as, according to the court, the abuse lies in the multiplicity and manner of the exercise of the right, rather than the exercise of the right per se. See the case of Ume and another, and Iwu and other, citation captured. The case of Dana Airlines Limited and Bami and another, citation captured. In determining whether or not this action filed by the claimant is an abuse of court process, I will consider the processes before the court, and particularly exhibits T1 and T2 annexed to the counter affidavit in opposition to the notice of preliminary objection at pages 251 to 254 of the case of the records of this court, and also exhibit A1, A2, A3, and A4 annexed to the affidavit in support of the preliminary objection and the further and better affidavit in support of the objection. I perused these exhibits with the finery of a tooth comb and have equally compared them. It is clear from exhibit A, in this case, which is on pension and gratuity of the claimant, that it is the same with the one in the earlier suit filed. That is suit number NICN/ABJ/195/2016. The relief sought are not totally the same. In the earlier suit, claimant was asking the court to order the defendant to compute and pay him his accrued federal share of pension and gratuity for 27 years of service, and also to take into account the various percentages of increase in the computation of his pension via the 5 reliefs sought therein. In the instant suit, claimant is contending that he retired on grade level 17 as the Chief Inspector of Education, and that his federal share of pension should be calculated using that grade level and not on grade level 13 computed for him by the defendant. In this case, claimant sought 9 reliefs in all, while relief 7 was sought as an alternative to relief 6. In my considered view, though the issues in both cases are on claimant's pension and gratuity, the facts did not arise from the same set of circumstances. I say so in view of the fact that from a comparison of exhibit A1, A2, and A3 with the originating process in this case, together with the accompanying statement of facts, the earlier suit was instituted when claimant was paid the sum of 541,593 naira in 2015 by the defendant as a total sum of his federal share of pension for 27 years, and which led to a series of complaints by claimant, unlike this case, that arose after the defendant allegedly stated that claimant's federal share of pension was calculated thus because he retired on grade level 13 based on the computation provided by Sokoto state government, which led to a series of contentions between parties as to what grade level claimant retired. Hence the relief sought by claimant in this case. What I'm saying in essence is that the issues and relief sought in both cases, though, arose from similar facts, in circumstances, they are not totally the same. I'm also mindful of the import of Exhibits T1 and T2, which are notice of discontinuance of the suit number NICN/ABJ/195/2016, and the order of course striking same out pursuant to the said notice. The question one would then ask at this point is, what is the effect of filing notice of discontinuance? Is this the tried position of law that once a plaintiff or claimant, as in this case, has filed a notice of preliminary objection, has filed a notice of discontinuance, the life of the suit is terminated? In the case of Enhara and Health Management Board of Imo State, citation provided, it was held that a notice of discontinuance, once it is filed, the whole suit is deemed to have come to an end and does not require to be formally argued as a motion. In the same vein, the Supreme Court also held in the case of Ekundano and Kerigbe, citation captured those, and I quote, a plaintiff may, without leave of court, discontinue a suit against all or any of the defendants or withdraw any part of his claim before the date fixed for hearing. In such a situation, the notice of withdrawal automatically terminates the proceedings, unquote. Also, Idigbe emphatically held, does, and I quote, the vessel, quote, St. Roland and another versus Oshinloye, I think it ought to be noted that a notice of he held us in the case of the vessel St. Roland and another versus Oshinloye, citation captured, I quote, I think it ought to be noted that a notice of discontinuance, once duly and validly filed, cannot be recalled, for the suit ceases to exist the moment it is effectively discontinued. See also the case of Bieno and Orizu and others, citation captured. See also the case of Esogwa and others and Imosu, citation provided. The case of Imperial Homes Mortgage Bank Limited and Mount Gilga Investment Limited and others, citation provided. In fact, in the case of Banners Airlines Limited and Mobile Oil Nigeria PLC and another, citation provided, the court was of the view that once a notice of discontinuance is filed, the action is terminated and dead and can only be brought back to court by filing a fresh action and not by way of relisting. Therefore, it is clear from the above that once a notice of discontinuance is filed, an action is terminated and ceases to exist and can only be brought back to life by a fresh action. In my view, assuming all the facts and reliefs in the earlier suit are even the same with the ones in the instant suit, the mere filing of a notice of discontinuance and the order of course striking same out based on the said notice has clearly taken life out of that previous action which ceases to exist, and the only way same can be brought back to life is by a fresh action, which in my view was what the claimant sought to do with this fresh action. It is the position of this court that since the previous action is terminated and thus dead and forgotten, this action cannot be said to constitute abuse of court process by way of multiplicity of action with a dead suit which is already dead. I bear in mind the position of the defendant in their further and better affidavit in support of a notice of preliminary objection, stating that the ruling of my learned brother, Anuwe J, contained in Exhibit T2 is subject of an appeal, and in support of which it relied on Exhibit A4, annexed to the said further and better affidavit. First, I peruse the said Exhibit A4 at pages 263 to 267 of the record of this court, and it is clear therein that there is nothing to show that the appeal has even been lodged and appeal entered in the first place, because the copy of the notice of appeal filed as Exhibit A4 has no appeal number. There is equally nothing on it to show that same has been filed at the registry of the Court of Appeal, since the appeal borders on partly fundamental human rights on which the defendant could appeal without the leave of this court, or the leave of the Court of Appeal. To me, there is nothing before this court to show that the defendant is even interested in filing the notice of appeal. Thus, it cannot be said that there is a subsisting appeal before the Court of Appeal. In fact, the date on the said notice of appeal at page 267 of the record of court shows that it was done on 20th of June 2022 after the claimant had filed his counter affidavit to the defendant's notice of preliminary objection on the 6th of June 2026, as seen at page 251 of the record. In fact, it seems to me that the defendant purposely prepared the notice of appeal on the 20th of June 2022 for the purpose of a further and better affidavit in order to pull a wool on the face of the court, because it was a day after the said notice of appeal was prepared that the defendant filed its further and better affidavit, which means that the notice of appeal was prepared in contemplation of the further and better affidavit. Besides, the position of the law is clear that a judgment or order of court is valid and subsisting until set aside by an appellate. See the case of FRN Ozehome, citation captured, Isogwuye and Eyo and another citation provided. It is in the light of the above stated supra that I find that the claimant's suit is not an abuse of court process. I so hold. Issue 1 is thus resolved in favor of the claimant. Now to issue 2. A perusal of the originating process makes it clear that this action is declaratory. The law is of commonplace that in a case for declaratory relief as in the present, the claimant must succeed on the strength of his own case and not on the weakness of the defendants. On the preliminary, I would like to address the issues raised as to the admissibility of Exhibits A5 as raised by the defendant by paragraph 3, subparagraph 6 of its final written address at page 7 of the said address. According to the defendant, the document was neither front-loaded nor contained in the claimant's list of documents. It also contended that where it is held that the document has attained the conditionality of admission, the weight to be attached to it is in serious doubt. The above objection by the defense on the admissibility of Exhibit A5 on the ground that it was not front-loaded was equally raised when the document was about to be tendered on the 15th of March 2023. In fact, it was equally contended as regards the said document that same was also not pleaded. It is the position of the law that the test for admissibility is generally relevance. See the case of Kubo and another and Dixon and other citation captured. What determines the relevance of an evidence is the pleadings of the parties, since it is pleadings that contains the facts upon which evidence, whether oral or documentary, will be adduced. Insofar as what is pleaded is relevant, including the fact of existence of a document, such document is admissible in evidence. Claimant, by several paragraphs of his statement of facts, has averred that the Sokoto State correspondence to the defendant has stated that he retired as Chief Inspector of Education, grade level 17, step 5. Exhibit A5 is the correspondence referred to, as it was written to the defendant stating that claimant retired on grade level 17, step 5. Thus, the contention of a defendant during trial when Exhibit A5 was tendered that the document was not pleaded is unfounded. Besides, the law is settled that a document need not be specifically pleaded to be admissible in law. Once the facts contained in it are pleaded, then the document is admissible. See the case of CB Nigeria PLC, citation captured, and the case of Monia Construction Company and Azubike, citation equally captured. As stated supra, claimant by several paragraphs of his statement of facts referred to a correspondence of Sokoto State to the defendant, which stated that he retired on grade level 17, step 5. Exhibit A5 is the said correspondence in fact, the only correspondence of the Sokoto State to the defendant stating the claimant retired as Chief Inspector of Education on grade level 17, step 5. Thus, it cannot be said that the document was not pleaded. Sections 1 to 3 of the Evidence Act 2011 provides as follows, and I quote, evidence may be given in any suit or proceeding of the existence or non-existence of every fact in issue, and of such facts as are hereafter declared to be relevant, and of no others, provided that A, the court may exclude evidence of fact which though relevant or deemed to be relevant to the issue, appears to it to be too remote to be material in all the circumstances of the case. And B, this section shall not enable any person to give evidence if a fact which he is entitled to prove any provision of the law for the time being in force. Section 2, for avoidance of doubt or evidence given in accordance with Section 1, shall, unless excluded in accordance with this or any other act or any other legislation validly enforced in Nigeria, be admissible in judicial proceedings to which this act applies, provided that admissibility of such evidence shall be subject to all such conditions as may be specified in each case by or under this act. Section 3, nothing in this act shall prejudice the admissibility of any evidence that is made admissible by any other legislation validly enforced in Nigeria, unquote. From the above provisions of the Evidence Act, front-loading is not part of the requirement for admissibility. The provisions in the rules of this court for front-loading, also contained in the rules of other courts in this clime, is to save precious judicial time and to prevent springing of surprises by parties. It does not in any way relate to admissibility of a document. See the case of APC and another versus Obaseki and others, citation captured. The document was pleaded and the defendant was well aware that they would meet that document at the trial, especially where it is the major point of divergence between parties in this case. In fact, the defendant itself tendered it as Exhibit N1 and part of Exhibit N16. So it was neither ambushed nor taken by surprise, thus removing the element of surprise, which was the aim of front-loading. The admissibility of a said document was not affected by failure to front-load or list as part of it list of documents. See the case of Minister for Works, Housing and Urban Development and others versus Ogungbe, citation provided. However, there are other tests for admissibility that a document must pass apart from relevance to be admissible. One of such is if the document is not legally inadmissible or rendered inadmissible by any other legislation validly enforced in Nigeria. The said document is a certified true copy of a public document, and the defendant did not, in its objection, contend that it was not certified properly. In fact, the defendant equally tendered a certified copy of the document, like I said, as Exhibit N1, and also as part of Exhibit N16. The defendant has not told this court of any legislation which is validly enforced in Nigeria to render the document inadmissible. Therefore, there is nothing before this court impeding the admissibility of the said document, especially where the defendant equally tendered same as Exhibit N1, as I've stated earlier. Exhibit A5 is thus admissible, stands admitted, and forms part of the court's record. Also, the defense counsel during trial objected to the admissibility of Exhibit A6, the circular tendered by claimant on the ground that same is a public document and ought to be certified. Exhibit A6 are photocopies of the government circulars. Section 102 of the Evidence Act provides as follows, and I quote, "The following documents are public documents. A, documents forming the official acts or records of the official acts of 1, the sovereign authority, 2, official bodies and tribunals, or 3, public officers, legislative, judicial, and executive, whether of Nigeria or elsewhere, and B, public records kept in Nigeria or private documents," unquote. The only two pieces of public documents that are admissible are either the original document itself, which is primary evidence of itself, or is secondary evidence of same by way of a certified true copy where the original is not available. I've painstakingly perused Exhibit A6, and I find that it is unarguably a public document under Section 102 of the Evidence Act, and ought to be certified in line with Section 104 of the Evidence Act to be admissible under the Evidence Act. That is the position of the law as reiterated in these cases. The case of Danjuma and another, and Kashere, citation captured, Tabik Investment Limited and GTB PLC, citation captured, Magagia Nigeria Army, citation captured. I'm, however, mindful of the provisions of Section 12, subsection 2, paragraph B of the National Industrial Court Act 2006, hereafter referred to as NICA 2006, which empowers this court to apply the Evidence Act. But in appropriate circumstances, this court may depart from its provisions to serve the best interest of justice. The Supreme Court in the above case did not consider the provisions of Section 12(2)(b) of NICA, which allows this court to depart from the provisions of the Evidence Act in the quest for substantial justice. It is noteworthy that the provision of Section 12(2)(b) of NICA was affirmed by the Appellate Court in the decision of the Court of Appeal, Ilorin Division, in the case of Mr. Victor Adegboye and United Bank for Africa on reported appeal number CA/IL/20/2021, a judgment delivered on the 14th of April, 2022. I'm mindful of the fact that justice is not a one-way traffic. It is justice to both parties and equally to the court. Thus, acting in the interest of justice will mean to do an act that will engender justice to both sides, not just one side. The defendant in this case have also tendered photocopies of public documents that were not certified, which the court have not excluded. For instance, Exhibit N5, N6, N7, N8, N10, and N16 are photocopies of public documents which were not certified and ordinarily under the Evidence Act are not admissible, but which the court admitted in the interest of justice of this case. The Englishman says, what is good for the goose is also good for the gander. The interest of justice in this instance will only mean that Exhibit A6 should also be admitted, especially where the defendant is not contending the authenticity or veracity of its contents, and the said document is relevant to the cause of justice in this case. Accordingly, the objection of the defendant to Exhibit A6 is discountenanced. In this case, is claiming his federal share of pension, gratuity from the defendant. It is the contention of the claimant by paragraphs 11, 22, 30, and 38 of its statement of fact that he voluntarily retired as Chief Inspector Education, grade level 17, step 5, after 32 years of service of the northwest of northern Nigeria and Sokoto State. According to him, he voluntarily retired in September 1989 after 32 years of service, and that he was entitled to a dual gratuity and pension from Sokoto State and federal government respectively. He further proceeded that at no time the Sokoto State ever stated that he retired on grade level 13, step 5, but rather consistently maintained that he retired as Chief Inspector of Education, grade level 17, step 5. He tendered to substantiate his position as Exhibit A5, which is equally tendered by the defendant as Exhibit N1, which is the computation of pension/gratuity by the Office of the Head of Service, State Pension Office, Sokoto State. The defendant in this case is not saying that the claimant did not voluntarily retire. However, the area of dispute and contention of the defendant is that the claimant retired as Chief Education Officer, grade level 13, step 5, and not as a Chief Inspector of Education or Permanent Secretary, grade level 17, step 5. Again, the defendant, in a bid to substantiate his position, tendered Exhibit N10, which is a letter of confirmation of actual grade level for retired officers designated as Chief Inspector of Education, written to the Head of Service, Sokoto State, and Exhibit N11, which is a response from the Head of Service of Sokoto State attached with grading structure from Ministry of Establishment and Pension Matters, Sokoto. The defendant had in paragraph 3, subparagraph 6 of its final written address submitted that if the court holds that Exhibit A5, which claimant is relying on, is admissible, the way to be attached to it remains in serious doubt. Also, by paragraph 11, 4, and 5 of its statement of defense, it averred that the said Exhibit A5 was with several anomalies, like absence of the signature of the Auditor General of Sokoto State, as required by the defendant's policy, and that the computation sheet has alterations which clearly raise serious doubts about its authenticity and validity going by the warning stamp on it. I have perused carefully the said computation sheet, which is herein before this court as Exhibit A5, which is also Exhibit N1 and part of Exhibit N16, tendered by the defendant. Excuse me, please. Let me first say that the defendant has not placed before this court or refer this court to any policy of it that says that the document must be signed or authenticated by the Auditor General of Sokoto State for it to be valid. Excuse me, please, just a minute. Excuse me. Sorry, please, I needed to clear my throat. I'll take that again. Let me first say that the defendant has not placed before this court or refer this court to any policy of it that says that the document must be signed or authenticated by the Auditor General of Sokoto State for it to be valid. The said averment does belong to the realm of speculation, as there is no such policy before this court that states that Exhibit A5 must be authenticated by the Auditor General of the state. Besides, a perusal of Exhibit A5, N1, and N16 clearly show that someone signed and authenticated the document for the Auditor General of the state, as there is a stamp and date on the place required to be authenticated by the Auditor General of Sokoto State. In the case of Boye Industries and Oyewumi citation capture, the Apex Court held that while the Judicial or the effigy of justice may be blind, judges are not blind and should not be blind. I've also perused all these documents, and I'm yet to see any alteration on the said documents that would suggest that it is not authentic or valid, contrary to the claims of the defendant. As regards the contention of the defendant in its final written address that Exhibit A5 is not reliable and no weight should be attached to it because its content negates that of Exhibit N11 and the actual grade level on which the claimant retired, I must state that I have perused all the exhibit tendered by the claimant and that of the defendants with the mastery of an eagle eye. It is noteworthy that the defendant, upon its receipt of a disputed Exhibit A5, had before Exhibit N10 written to the Sokoto State government requesting for fresh computation sheet and for further clarification on the grade level that is equivalent to the Chief Inspector of Education in the State Civil Service, which request was contained in Exhibit N6. The said Exhibit N6 tendered by the defendants was written on May 14, 2015, and was pleaded by the defendant by paragraph 11, subparagraph 7 of his statement of defense. The defendant by paragraph 11, subparagraph 8 of the statement of defense had averred that the Sokoto State government responded to its letter by a letter marked, reference ESTB/PEN/04/volume dated 24th of July, 2014, stated that they were not able to trace claimant's record of service owing to movement of personnel and other government documents during state creation. The dates pleaded are not even chronological. By the above averments, the letter number ESTB/PEN/04/volume dated 24 July 2014, was written by Sokoto State Government in response to the defendant's letter of May 14, 2015, which is herein as Exhibit N6. How possible is it for a response to predate the letter or the date on the letter it is responding to? That is practically impossible. The defendant also averred further, read paragraph 11, subparagraph 9, that surprisingly, another computation sheet was sent to it by Sokoto State Government, which was duly stamped and signed by the Auditor General of the state dated 25th of May 2015, and which was what it eventually used to compute pension arrears of claimant, though in the absence of other vital documents. The fact that it relied on the computation sheet endorsed by Sokoto State Auditor General was equally contained in paragraph 7, subparagraph 9 of the Statement of Defense. This fact was equally stated by the defendant in Exhibit N13. It is the duty of he who asserts to prove what he has asserted, whether positive or negative. Since the defendant is asserting that it computed claimant's pension based on the new computation sheet different from Exhibit A5, which was sent to it by Sokoto State Government, it has the onus to prove its assertion by presenting the said document before the court. I peruse all the documents tendered by the defendant, that is Exhibit N to N18. None of the two documents pleaded in paragraphs 11, 8, and 9, that is the purported Sokoto State Government letter dated 24th of July 2014, stating that claimant's record could not be traced, and the purported computation sheet, which the defendant alleged was forwarded to it by Sokoto State Government dated 25th of May 2015, and which according to it was what it eventually used by calculating claimant's pension, and on which basis it is saying claimant retired on grade level 13, step 5, and not 17, step 5, is not before this court. The ipsi dixit of DW in his written statement on oath on the computation sheet received from Sokoto State Government, and which was eventually what the defendant used as contained in paragraph 14, 8, subparagraph 8 and paragraph 15, which seek to support the averment of the defendant in paragraph 11, subparagraphs 8 and 9, is without evidential value, as the said computation sheet was contained in the document. This is because it is a standing rule of evidence that oral evidence is excluded by documentary evidence. Thus, whenever a fact is contained in the document itself must be the evidence that speaks for itself and not any oral evidence. Since the said purported letter gotten from Sokoto State in response to Exhibit N6 and the purported computation sheet, which was pleaded in paragraph 11, subparagraph 8 and 9, were documented, DW cannot give evidence of its contents. See the case of Mwana and Okeyocha, citation captured, the case of Alao and Alabi, citation equally captured, and section 128 of the Evidence Act 2011. As reason supra, the defendant claimed to have relied on a computation sheet sent by Sokoto State Government as pleaded in paragraph 11.9, stated above. However, DW, while under cross-examination on the 15th of March 2023, seems to be stating the exact opposite. He was asked, and I quote, question, look at Exhibit N13. That is the computation sheet. In placing the claimant on GL 13 step 5, you relied on a letter from Sokoto State, particularly the computation sheet. He answered, not exactly. He submitted a computation sheet from Sokoto State Government, but as a lot of alterations and not endorsed by the State Auditor General, we turned it back. We placed him on sympathetic pension on a letter initially, but subsequently jettisoned the circular from Sokoto State. But we relied on the circular from Sokoto State Head of Service and also on the pension harmonization table. The claimant's name is on the document. Claimant tendered in Exhibit N13. Question, Exhibit N13, page 50 to 51, that is the letter you relied on. Answered, yes, unquote. From the above line of questioning and answer, DW is saying that no computation sheet was relied on contrary to the averments in paragraphs 11, subparagraph 9 of the Statement of Defense, and his own evidence in paragraph 15 of a written statement on oath. Instead, he's saying what the defendant relied on to compute claimant's pension was the letter contained at pages 50 to 51 of Exhibit N13, which letter I find to be the same as Exhibit N11, which is the letter forwarding the grading structure in Sokoto State to the defendant, which document is not a computation sheet, and in fact cannot be the computation sheet referred to in paragraph 7, subparagraph 9, and paragraph 11, subparagraph 9 of the Statement of Defense, or paragraph 15 of DW Statement on Oath. In the case of Wikwe Benikan and the state citation capture, it was held as, and I quote, "A piece of evidence is contradictory to another when it is said to affirm the opposite of what the other asserts, and not necessarily when there are I will take that again. A piece of evidence is contradictory to another when it is said to affirm the opposite of what the other asserts, and not necessarily when there are some minor discrepancies in details between both pieces of evidence," unquote. The evidence of DW is contradictory to the pleadings of the defendant. If one is to go by answer of DW under cross-examination, the defendant itself, without any computation sheet, decided to place claimant on grade level 13, which is Chief Education Officer going by Exhibit N11. DW himself had equally answered under cross-examination that the rank of Chief Inspector of Education is not synonymous with Chief Education Officer. The evidence of DW under cross-examination was not feeble and has been obviously shaken. The evidence of DW in this respect contradicts the defendant's case, and this incongruity and conflicting evidence is against the defendant and strengthening the claimant's argument against the pension computation made for him. This is more so since the defense of the defendant on placing claimant on grade level 13, step 5, was woven around the purported second computation sheet received from Sokoto State government, and also a party must be consistent in its case. The inconsistency created by the testimony of DW is fatal. In the case of Ige and another Anakoju and other citation captured, Olotawura Jesse of blessed memory held, and I quote, "When the evidence of a witness in court is different from the facts pleaded or is contradictory to the facts pleaded, such evidence should be rejected." Unquote. See also the case of Igokwe and Okadigbo citation captured, Etim and Akpan and other citation captured. Thus, the inconsistency in the testimony of DW under cross-examination is fatal to the case of the defense. I'm also mindful of the submission of learned counsel for the defendant in paragraph 8.06 of his final written address that placing claimant on grade level 13, step 5, was based on the grading structure received from this SSG of Sokoto as canvassed in the written address, as there was no document to be relied upon in placing and computing claimant's pension. This clearly negates the averments of the defendants in paragraph 11, subparagraph 9 of his statement of defense, and also paragraph 12, subparagraph 2 of the statement of defense. It is a settled principle of our law that a party must be consistent in the presentation of its case. See the case of Zibiri and another versus Amuda citation provided. The case of Abuse and Odili citation captured, Greenfinger Agro Industries Limited and M. Yusufu citation also provided. Specifically, in the case of Ali and another, and Obuagbe and another citation provided, the court held entirely outdoors, and I quote, "Thus, whilst a party will not be allowed to present at the trial evidence which are inconsistent with the case he has pleaded, so also should the counsel not indulge himself in putting forward or holding on to obviously inconsistent positions or presentations in his submissions on behalf of the litigants. Indeed, consistency is the very first hallmark of truth in a case and also of excellence of a legal practitioner," unquote. Learned counsel is bound by the pleadings of the defendant. The submission of learned counsel above constitutes a voyage away from the real meat and substance of the case of the defendant as put forward in its pleadings. The position canvassed in the final written address above is grossly inconsistent with the case the defendant has set out in its pleadings. The averment of the defendant and written statement on oath of DW cannot be saying one thing, while DW will be saying another under cross-examination, and counsel will be saying something else in his written address before the court. Consistency is one of the hallmarks of truth in litigation and also of excellence of counsel as held by the Court of Appeal in Ali's case supra. The defendant cannot change horses midstream. It is not possible. Accepting the submission of learned counsel above will be tantamount to allowing the defendant change horses midstream or change the rule of the game midstream. It is also worthy of note that Exhibit N10, which was written to Sokoto State government and in response to which the state wrote Exhibit N11, was not particularly in respect of claimant, and as was Exhibit N6. In fact, by the time the defendant took its action of placing claimant on grade level 13, step 5, and paying him federal share of pension on that level, Exhibit N10 and N11, on all N11, has not been written. According to defendant in paragraph 7, subparagraph 9 of the statement of defense, it relied on a computation sheet, a resolution of the meeting of the 3rd of August 2015 to compute claimant's pension, and same was paid to him as far back as August 2015 when Exhibit N10 or N11 was not in existence. The purported computation sheet, which it allegedly relied on in making the said computation, as reasoned earlier in this judgment, has not been placed before this court. In fact, neither the minutes of meeting of the 3rd August 2015, nor the resolution reached therein, which they equally alleged to have relied on, in addition to the purported computation sheet, has been brought before this court. In the absence of the purported computation sheet, the minutes of meeting of the 3rd August 2015, or the resolution of the purported meeting, Exhibit N10 and N11, which was written about 5 years after the defendant had taken his decision to place claimant on grade level 13, step 5, cannot justify defendant's action. Since the defendant has failed to place those documents it relied on before this court believes its decision to place claimant on the said grade level is arbitrary and unfounded. Also, Exhibit N10 shows that there has been myriads of complaints from persons who retired from Sokoto State. And I will capture salient part of Exhibit N10 does. Quote, confirmation of actual grade level for retired officers designated as Chief Inspector of Education. I wish to bring to your notice the plethora of complaints coming to Pension Transitional Arrangement Directorate, also known as PTAD, from retired Sokoto State civil servants with federal share of pension under the Defined Benefit Scheme, DBS, on short payment or non-harmonization of their monthly pension due to application of wrong grade level and designations at their date of retirement. Paragraph 2. In view of the above and to bring a lasting solution to these complaints, the Directorate will appreciate you avail her a comprehensive list of the state grading structure, including therein a clarification as to the appropriate grade of retired Chief Inspector of Education. 3, please accept the assurances of the Executive Secretary, esteemed regards, unquote. It is clear from the content of Exhibit N10 captured above that it was as a result of general complaints by retired Sokoto State civil servants that the letter was written, and not specifically written in respect of the claimant. The content of Exhibit N11, which was written in response to Exhibit N10, which states that there was nothing like Chief Inspector of Education in the state, is no doubt not a computation sheet or a record of service of the claimant. It is noteworthy that the Sokoto State government had issued Exhibit N8, also tendered by the defendant as far back as 2014, and it negates the content of Exhibit N11. Exhibit N8 is also part of the annexures to Exhibit A4, tendered by claimant, The defendant who tendered Exhibit N11, which states that there is no grading structure in Sokoto State like Chief Inspector of Education, is the same person that tendered Exhibit N8, which is a letter from the same Sokoto State Pension Department dated 24th of July 2014 to the defendant stating that claimant retired as Chief Inspector of Education. Put differently, the defendant who tendered Exhibit N11 and who will want the court to believe that there was nothing like the rank of Chief Inspector of Education was the same person who tendered Exhibit N8, which even predates Exhibit N11 from the same Sokoto State government and states that claimant retired as Chief Inspector of Education. The said letter was even written before the disputed Exhibit A5, which was in 2015. It is expedient that I capture the content of paragraph 2 of the said Exhibit N8, which is also part of the annexures to Exhibit A4, and it reads thus, I quote, "However, I am further directed to confirm beyond doubt that Mr. Theophilus T. Ajayi have served the former Northwestern State and Sokoto State government for 32 years, and he voluntarily retired from the service in the year 1989 as Chief Inspector of Education," unquote. The above is in sync with his rank recorded in Exhibit A5, which is also Exhibit N1 and N16, which came earlier before Exhibit N11. It is therefore clear that claimant was not just grandstanding when he said he retired as a Chief Inspector of Education. The defendant did not at any stage of its pleadings before this court state that it sent Exhibit A5, which is also Exhibit N1 or N8, to the Sokoto State government to confirm the authenticity or validity. In the absence of any evidence, Exhibit A5 and N8 are authentic documents which emanate from the Sokoto State government. As reason supra, claimant in support of his assertion that he retired as Chief Inspector of Education on grade level 17, step 5, relied on Exhibit A5, which shows the computation of his pension and the grade level on which he retired together with his rank. The defendant who wants the court to believe the contrary, a claimant retired on grade level 13, step 5, based on a purported computation sheet, failed to provide the said computation sheet before this court, as I've stated earlier. In fact, claimant's position as reason supra is also supported by Exhibit N8 tendered by the defendant, which states that claimant retired as Chief Inspector of Education. In my considered view, Exhibit N11, which was not particularly directed to claimant, is not enough to discredit the content of Exhibit A5 and N8, especially when it came much later than those documents. In the absence of a purported computation sheet, which the defendant alleges relied on, the court cannot fault the content of Exhibit A5 and N8. It is in the light of all the above that I find that reliefs 1 and 2 in the general form of complaint succeed. I still find and hold. It is also claimant's contention that his pension and gratuity from certain period was not paid. Specifically, claimant stated via paragraphs 14, 34A and B of his statement of facts that PTAD has refused to pay its share of the gratuity and that he was not paid pension from 1989 to 2002, under the guise that it is only liable to pay pension or gratuity to the claimant from June 2002 when he took over. The defendant, in response, by paragraph 7 of his statement of defense, proceeded that the federal government took over direct payment of gratuity and pension of state with federal share from 1st of June 2002 as a result of the defendant's ability to state pensioners for any federal share, gratuity, or pension commenced from June 2002 and not before it, while contending that the claimant is not qualified for payment of pension or gratuity under the defendant's scheme because his retirement predates 1st of June 2002. Claimant position that is entitled to federal share of pension from 1989 to 2002, and the same was not paid to him, was not controverted by the defendant in its pleadings. Claimant was also not cross-examined on this material point, and the position of the law is clear that failure to cross-examine a witness on a material point in the case signifies acceptance of the testimony on the particular material point. See the case of Esenia and the state citation capture, Taiwan and Adegboro citation provided, case of Gaji and others at Baye, citation provided, Amadi and Ingosu, citation equally provided. By the uncontroverted evidence of claimant, he has worked under the promises of government of the northern Nigeria before the creation of state. There is no doubt that he is entitled to federal share of pension. The defendant, on the other hand, are not saying claimant is not entitled to his federal share of pension for those years. Rather, what the defendant is saying is that it is not liable to pay claimant because the federal government only just took over payment of federal share of pension to state pensioners on the 1st of June 2002, and it relied on Exhibit N in support of this. Exhibit N is a circular issued on the 9th of May 2002. And I will at this stage captivate the attention of this court. It stipulates, and I quote, direct payment of federal pensioners and state pensioners with federal share. I wish to draw your attention to the decision taken at the consultative meeting between the Permanent Secretary, Establishment and Pensions and the Office of the Head of Service of the Federation, with state permanent secretaries for establishment and pension and state accountant general, both in Jos and Umuahia, to the effect that the Office of the Head of Service of the Federation, OHCSF, should start direct payment of all federal pensioners and the state pensioners with federal share with effect from 1st June 2002. You are therefore requested to inform all federal pensioners and state pensioners with federal share in your state to supply the names of their banks and the account numbers to the Office of the Head of Service of the Federation before 30th of May 2002. Paragraph 2. Henceforth, payment will no longer be made by cash or check, but by telegraphic transfer to pensioner bank accounts. Pensioners without bank accounts should open them immediately to avoid delay in payment. And paragraph 3, your cooperation will be highly appreciated, unquote. It is important, as stated here, the settled principle of law that interpretation of statutes are the same as in the interpretation of documents. See the cases of Adams and Umar, citation capture, the case of Ubona and AG of Imo State and other citation provided. In the interpretation of documents or statutes, the document or statute must be given holistic view and not just reading parts in isolation. The object of interpretation is to discover the intention of the maker. This is deducible from the words used, as the words used are the keys to unlock the intention of the maker. Supreme Court Per Adio, GSC, had this to say in the case of Union Bank and Ozigi citation provided, I quote, the words in the document must first be given their simple and ordinary meaning, and under no circumstances may new or additional words be ported into the text unless the document will be, by the absence of that which is imported, impossible to understand. The presumption is that the parties have intended what they have in fact said, so that their words must be construed as they stand. By the content of Exhibit N, the head of service of the Federation was with effect from 1st June 2002 to start direct payment of the federal share of pension to all state and federal pensioners with federal share by way of telegraphic transfer to bank accounts. Thus, federal share of pension will no longer be made by cash or check, but by telegraphic transfer to pensioners' bank account. The date of the 1st of June 2002 date referred to in the said Exhibit N is only in relation to when the direct payment of federal share of pension into the bank accounts of pensioners will begin. There's nothing in that document to suggest that the federal government only just took over payment of federal share of pension to state pensioners with federal share of pensions on the 1st of June 2002. Paragraph 2 of the letter is clear, with an opening word, thus I quote, henceforth, payment will no longer be made by cash, unquote. This clearly indicates that hitherto payments have been made by cash or check to beneficiaries, and the purport of the letter is to inform them that payment will no longer be made by direct transfer, that payment will now be made by direct transfer into their bank accounts. Hence, they were ordered to open an account. Therefore, the interpretation given to Exhibit N by the defendant is manifestly incorrect. Assuming the interpretation given by the defendant to Exhibit N7 at paragraph 7 of his statement of defense is even correct, if the claimant retirement predates the period the federal government took over liability of pension to state pensioners for federal share of pension and gratuity, the question that comes to my mind at this stage will be, who will pay for that period? Does it mean that claimant will have to waive or overlook the payment of his pension for those periods? Is the federal share of gratuity not the liability of federal government to pay? In my view, it is the liability of federal government to pay its federal share of pension or gratuity. It is not a liability of a state. Where a state pays it, it only does so on behalf of federal government, and it will in turn seek reimbursement from the federal government whose liability it is to pay the federal share of pension. In fact, paragraph 7, subparagraph 2, and Exhibit N17 lends credence to this fact. Assuming a state refuses to pay the federal share of pension to a state pensioner, federal government still owes the liability. Since the defendant is not disputing claimant's claim as not being paid during those periods, his federal share of gratuity, same is still the liability of federal government to pay, especially where there is nothing in Exhibit N17 that shows that claimant's federal share during the said period was part of the sum claimed as reimbursement by Sokoto State in Exhibit N17. There's nothing in Exhibit N17 that shows that claimant's entitlement was part of the entitlement referred to in it. Besides, in labor jurisprudence, it is a standing principle of law that any ambiguity that exists as regards payment of any entitlement to an employee, it must be resolved in favor of the employee. See the decision of this court in the case of Chiroma and Fort Oil PLC on reporters suit number NICN/ABJ/165/2018, delivered on 2nd of May 2019 by Justice B.B. Kanyip, PhD, now president of the court. The case of Ulade and Nigeria Agip on reporters suit number NICN/LA/41/2012, delivered on 12th of July 2016 by Honorable Justice B.B. Kanyip, PhD, now president of this court. The above position of the law decided in the above cases was given judicial approval by the Supreme Court in the case of NNDC versus Ugbaegbe, citation capture, where the court per Oyewumi GSC, while delivering lead judgment, held us, and I quote, on the auxiliary issue of who should pay the full pension of a retiring person, the Pensions Act in sections 15 and 16 is not specific on the point whether the last employer should pay all entitlements and seek reimbursement from previous employers or pay only for the period the employee worked for it. However, it is a principle of labor law that any ambiguity regarding the payment of any entitlement to an employee, it must be resolved in favor of the employee, in this case, the retiree. I cite with approval Chiroma and Fort Oil PLC, suit number NICN/ABJ/165/2018, delivered on 2nd of May 2019 by Justice B.B. Kanyip, PhD, Ulade and Nigeria Agip, NICN/LA/41/2012, delivered on 12th of July 2016 by Honorable Justice B.B. Kanyip, PhD. Thus, the rule of the retiree getting his full pension and gratuity from his last place of employment and the last place to get reimbursed by previous employers is born out of the fact that the method most practicable and most humane to the employee must prevail, unquote. Abubakar JSC on his own part, in his concurring judgment held inter alia those, and I quote, I am of the view that where there is seeming ambiguity in the payment of entitlement of an employee, such ambiguity must be resolved in favor of the employee, unquote. In view of the above position of the law, it is only humane that the defendant, who is the person who has the liability to pay federal government pensioners who are under the previous pension scheme, a category which claimant belongs to be made to pay claimant his pension from 1989 to 2002. Even if it is true, though I do not concede to the defendant's argument that federal government only took over payment of federal share of pension to state pensioners in 2002. By the provision of Section 33 of the Pension Reform Act 2004, which originally established the defendant, but in the name of Pension Transitional Arrangement Department before it was renamed Pension Transitional Arrangement Directorate by the Pension Reform Act 2014, hereafter referred to as the 2004 Pension Act. 2014 Pension Act. It is the mandate of the defendant to pay gratuity and pension to the existing pensioners and the category of officers exempted under Section 8 of this Act, in accordance with the relevant and applicable computation under the existing pay-as-you-go pension scheme of the Public Service of the Federation and Federal Capital Territory. The claimant was an existing pensioner under the defined benefit scheme and thus entitled to be paid his federal share of pension and gratuity, which is the mandate of the defendant, which was established as at the establishment of the defendant, and it must of course be paid by the defendant since Sokoto State has failed to pay him on behalf of federal government. Onohen JSC, CGN retired in the case of Central Bank of Nigeria versus Amao and others. Citation captured, admonished those, and I quote, "It is important for every organization in this country, including the appellant, to wear human face in its treatment of the people, particularly senior citizens, because it will be anybody's turn tomorrow to be a senior citizen. We must re-examine our attitude towards the senior citizens of this country so as not to make them regret their sacrifice for the nation in whatever capacity. The respondent need not be put to the expenses of litigating this matter in the first place, let alone all the way to the Supreme Court," unquote. In the case of NNPC and Komolafe citation captured, Idigbe CA held inter alia those on pensions right, I quote, "It has always been said that rest is sweet after labor. The laborer is entitled to his wages and entitlements upon his retirement in accordance with the conditions of his employment, and the court will not allow any unjust denial of terminal benefits to a retiree." Porous defense put up by the appellant, as earlier on highlighted, are barefaced afterthought and a malicious act on the part of the appellant to deny the respondent's entitlement, particularly his pension and gratuity, unquote. Upholding the defendant's stance that claimant is not entitled to be paid for those periods because the defendant's liability only start from June 2002 will be tantamount to compelling claimants to waive his accrued entitlements. It is a standing principle of labor law that an employee cannot be compelled to waive any of his statutory rights, which is often referred to as the principle of non-waivability, except perhaps where the employee voluntarily exercises such right, which is not the case herein. Now, right to pension and gratuity of a retired officer is a constitutional right. Section 173, sections 1 and 2 of the Constitution 1999, as amended, provide those, and I quote, "Subject to the provisions of this Constitution, the right of a person in public service of the Federation to receive pension or gratuity shall be regulated by law. 2, any benefit to which a person is entitled in accordance with or under such law or referred to in subsection 1 of this section shall not be withheld or altered to his disadvantage, except to such extent as is permissible under any law, including code of conduct," unquote. Section 210, subsection 1 and 2, I quote, "Subject to the provisions of subsection 2 of this section, the right of a person in public service of the state to receive pension or gratuity shall be regulated by law. Subsection 2, any benefit to which a person is entitled in accordance with or under such law, as is referred to in subsection 1 of this section, shall not be withheld or altered to his disadvantage, except to such extent as is permissible under any law, including the Code of Conduct, unquote. It is clear from the above that entitlement to pension and or gratuity is a constitutional right of employee in the public service of the federation or of the state, and same cannot under any guise or ploy be taken away from such officer or altered to his disadvantage. Claimant is undoubtedly entitled to his federal share of his pension and gratuity during those periods. The defendant is under a constitutional duty to pay claimant, and it cannot under any guise withhold same from the claimant. The court in the case of Ajao and Permanent Secretary, Ministry of Economic Planning, Budget, Civil Service Pensions Office, and another citation captured held inter alia that payment of pension does not depend on the discretion of government, but is governed by the rules, and anyone entitled to pension and or gratuity can claim it as a matter of right. The defendant cannot, on its erroneous interpretation of Exhibit N, rely on its discretion to deny claimant his federal share of pension for the period of 1989 to 2002. It is in view of the above that claimant's relief 3 in the general form of complaint succeeds. Claimant by relief 4 is seeking for an order of this court compelling the defendant to pay to him the sum of 1,603,573 naira being his due gratuity from the defendant as assessed or stated on the computation sheet forwarded to the defendant by Sokoto State. Monetary claims are no doubt in the realm of special damages, which must be specifically pleaded and with distinct particularity and strictly proved by credible evidence. See the case of Ene and Ozo and another, Ajikbo Tosho and RCC, the case of Abi and CBN, Yaya and Okwari Day, citation provided. The claimant in his pleadings did not specifically plead with distinct particularity how he came by the quantum of the sum of 1,603,573 naira claimed as his federal share of gratuity, even though the court has found that he is entitled to be paid. He also relied on Exhibit A5, which is also Exhibit N1 in proof of the sum of 1.6 million naira. I peruse Exhibit A5, which is the same as Exhibit N1. It is true from the said document that the federal share of pension was calculated as 1.6 million, which is also the same figure calculated as the state share of pension. However, the failure of claimant to plead with distinct particularity how this sum was arrived at is fatal to his case. A claim for special damages must be based on the precise calculation shown by the particulars given, and such claim based on mere estimate or estimation of the claimant is not precise. It is for this reason that this court is not inclined towards granting the relief of the claimant for the above sum claimed. Thus, relief 4 failed. Claimant by relief 5 seeks for an order of this court compelling the defendant to pay him the sum of 19,939,397 naira 78 kobo, being the short payment or differential of pension based on grade level 13, step 5. Specifically by paragraph 23 of the statement of facts, claimant averred that the approved pension review or increases of 142% of 1999, 6% of 2003, 15% of 2007, 33% of 2010, 9% of 2019 were not reflected in his pension payments. In support of this, he relied on Exhibit A6. Exhibit A6 is a bunch of series of government circulars by the decision of the Apex Court in the case of NNDC and Ugbaigbe Supra, particularly at page 40, paragraph B. A retired public servant can take advantage of relevant government circulars for the computation of pension. Therefore, claimant in this case can take advantage of the relevant circulars in Exhibit A6. Howbeit, Claimant in this case is seeking the particular monetary sum of 19,939,397 naira 78 kobo, which is special damages. As reason supra, special damages must be specifically pleaded with distinct particularity and strictly proved by credible evidence. See the case of Idigbe and RCC supra. For such claim to succeed, claimant must be able to specifically plead this sum by giving particulars of how he came by the quantum of the sum claimed and prove same by cogent and credible evidence. The claimant in this case, just as it was with the sum claimed in the preceding relief 4, as federal share of gratuity, also failed in this case to give distinct particulars of how he came by the quantum of the sum of 19.9 million naira claimed as differential on the wrong placement as level 13, step 5. Thus, this head of claim cannot succeed. Accordingly, this relief must also fail. Thus, relief 6 fails. Claimant by relief 7 is seeking for a relief in the alternative to reliefs 5 and 6, compelling the defendant to immediately cause all claimant pensions benefits to be transparently computed on grade level 17, step 5, and provide for all the pension payments deficit and settled and or pay all his pension entitlements into his designated bank account within 30 days of delivery of judgment. It is the law of common that an alternative claim can only be considered by a court after the main claim has been considered and refused. See the case of Dong and Attorney General Adamawa State, citation captured. Air Liquid Nigeria PLC and NAM, citation provided. Caroline Mesk versus Nokoi Investment Limited, citation provided. Case of Merchant Bank and Adalma, citation also provided. The reliefs of the claimant in reliefs 5 and 6 have failed, and he sought relief 7 as an alternative to them. Thus, the court could consider his relief 7 in the alternative. Claimant had in several paragraphs of the statement of fact averred that it was placed on the wrong grade level by the defendant when he computed his pension payment. And as a result, in this relief sought that his correct pension on grade level 17, step 5, be computed. He had also in paragraph 23, as stated supra-averred, that the approved pension reviews increases of 142% of 1999, 6% of 2003, 15% of 2007, 33% of 2010, 9% of 2019 were not reflected in his pension payment, which were already paid to him. It may seem that these facts are conflicting as he is in one breath asking for differential of payments paid to him based on grade level 13, step 5, which he has contended as the wrong grade level, and also in another breath, be asking that his federal share of pension be computed using grade level 17, step 5, and paid to him. The position of the law is now settled that a party who seeks relief in the alternative can plead conflicting facts in line with the alternative relief sought. See the cases of Mr. Peter Gregory Obi and another versus Independent National Electoral Commission and 3 orders on reported petition number CA/PEPC/03/2023 versus Allied People's Movement versus Independent National Electoral Commission and 4 orders on reported petition number CA/PEPC/04/2023 versus Abubakar Atiku and another versus Independent National Electoral Commission and 2 orders on reported petition number CA/PEPC/05/2023 at page 33 of the judgment delivered on the 6th of September 2023. The case of Abia State Independent Electoral Commission and Kanu, citation captured. The case of Idigbe and Nwagu, citation equally captured. It is thus clear from the above cited recent decisions that claimant is allowed to plead conflicting facts in line with the alternative relief sought. The court has made a declaration in relief 1 that claimant retired on grade level 17, step 5 as a chief inspector of education. However, as agreed by parties in this case, the defendant computed for claimant his federal share of pension on grade level 13, step 5, which this court has, for reasons earlier stated in this judgment, found to be wrong. In the case of NNDC and Idigbe Supra, particularly at page 40, paragraph A, Abubakar GSC in his contributory judgment had this to say, I quote, "It is correct that where there is failure to conduct correct and precise computation of a person's entitlement, he'll be entitled to bring an action to ensure adequate and proper computation," unquote. There is no doubt that claimant has a right to bring an action for the correct computation of his entitlements and seek a differential, as he did in this case. In view of the above, it is only expedient that the defendant be compelled to correctly compute claimant's pension on his appropriate grade level 17, step 5, on the rank of Chief Inspector of Education and pay him all the deficits. It is in the light of this that I find that relief 7 succeeds. By relief 8, claimant is seeking for general and or aggravated damages in the sum of 100 million naira for deliberate refusal of the defendant to work with the information from Sokoto State Government. In the case of Eliochin Nigeria Limited and Imbadiwe citation captured, Obaseki GSC of blessed memory stated those, and I quote, "It was not possible to say there was a dividing line between them, that is, general damages and aggravated damages," unquote. There's no gainsaying the fact that both general and aggravated damages are compensatory damages. Earlier in this judgment found that there were no alterations on Exhibit A5 to warrant the defendant to reject it. I've also found that the defendant has failed to place before this court the purported computation sheet it relied on and the alleged resolution of meeting that justifies its action of placing claimant on grade level 13, step 5, and paying him pension on that grade level. I equally held earlier in this judgment that based on the above reasons, the act of the defendant of placing claimant on grade level 13, step 5 was arbitrary. In law, general damages is presumed. There's therefore no doubt that the acts of a defendant have caused claimant some sort of hardship, especially with his age pleaded in his statement of facts. Section 19D of National Industrial Court Act 2006 empowers this court to award compensatory damages in deserving cases. In line with this power granted, this court award the sum of 500,000 naira as general/aggravated damages in favor of the claimant. I so award. The claimant by relief 9 is asking for the cost of action. He, however, did not assess the cost, but passed the burden of its assessment to the court. Claimant in this case has succeeded in the most part of his claim. In the case of Kappa and Alberto, Nigeria PLC and NDIC citation captured, the Supreme Court held that a successful party is entitled to costs which it should not be denied except for good reasons. See also the case of First Bank and Orosai citation captured. In the same vein, the same Apex Court, in the case of Mekuya and Emirates Airlines, citation provided, held inter alia that costs, including costs of litigation, is at the discretion of the court once empowered by its rules, and that the Court of Appeal in that case was wrong to have held that the award of costs in that case amounted to granting special damages not proved. Thus, it means that cost of action may be granted even where not proved, provided the court is empowered by its rules to grant same. This court has similar provisions as that of the Federal High Court relied upon and considered by the Supreme Court in the case of Mekuya and Emirates Airlines Supra. By Order 55, rules 1, 2, 3, 4, and 5 of the rules of this court is empowered to grant cause of action at its own discretion. The discretionary power of the court is to be exercised judicially and judiciously. Claimant in this case, including his counsel, were in court most times of sitting, except when it was reported that he had an eye surgery. He did not misbehave nor misconduct himself throughout the trial. Claimant in the instant suit has equally succeeded in the most part of his claim. I therefore find it just to exercise my discretion in his favor. In exercise of the powers bestowed upon this court by the rules of this court, I award the sum of 250,000 naira as cost of litigation in this suit. I so award. For the avoidance of doubt and the reasons earlier given, I declare an order as follows. 1, claimant voluntarily retired in 1989 on grade level 17, step 5 as Chief Inspector of Education. 2, the placement of claimant on grade level 13, step 5 by the defendant is or travails arbitrarily and unconstitutional. 3, the claimant is entitled to be paid his federal share of gratuity by the defendant. 4, the defendant is to compute within 14 days of this judgment the federal share of a pension of claimant on grade level 17, step 5, and pay the difference on deficit to claimant designated bank account forthwith. 5, claimant is to be paid 500,000 as general damages. 6, claimant is entitled to be paid 250,000 as cost of action. And 7, this judgment is to be complied with within 30 days from today, failing which it would attract 10% post-judgment interest. Judgment is accordingly entered. Counsel, you will have copies of this judgment. You may pick it up if you so wish.
As a copy, we must thank your lordship for the industry committed into this judgment, and we thank your lordship again for being humane to the claimants and hold man and the retiree for that. We thank your lordship. We are very grateful, sir. And I'm very sorry for getting him to Zoom meeting very late. It's due to network challenges here. I thank your lordship, sir.
Very well.
My lord, on my part, I'm so much glad in the industry in writing the judgment. And we are going to get a copy and study it and also do the needful where the cause arises. Thank you so much, my lord.
Very well. So the court will rise. Like I said, you can obtain a copy tomorrow.
Yes,
Very well, I arise.
Thank you, Mr. Adams. But it's okay.